it's your old buddy Brian Parker. I am still stuck in Detroit. The snowstorm came through that I alluded to when I was in my car doing the video on the appeal I did on Tuesday in Detroit. I'm now stuck in my kid's apartment. Court just got wiped out and canceled, so it's a free day. So I'm in a sort of a location like a witness protection program. Anyway, so what happens is when you go through a big case, before and after there's issues. Before is all that preparation I talked about leading up to the Court of Appeals appearance. Then afterwards you start questioning yourself. Hey, maybe I didn't do as well. Oh, I forgot. You always forget something. It's unfortunate. But there's only so much. If you remembered everything, you're probably saying too much. So as you saw in that video I did, I had one sheet of paper because you got to keep it simple, stupid, and you can't overwhelm people. So one of the things I went through my head is, I didn't talk about the bill of sale enough. So I'm going to talk about the bill of sale now. And the relevance for you, sorry about using that word, but the relevance for you is it's a gold mine. Why? If you're in a deep bind in your case, or you just want to win and settle this dog, the best thing right now to do is to find a pressure point. And if you get to do discovery, there's three things you need to do. I'm not a big proponent of it, but parts of discovery can settle your case quickly with the right, usually debt buyer or student loan debt buyer case. And that means that you have to find their Achilles heel. What makes them go, I'm not giving that up. I have it for you, and they've given it to you. As you know, I'm a big proponent, use their records against them. Well, today we're going to see something so cool, it's too simple. How could that possibly be? But I'm going to show you why, and at the end I'm going to show you how to get what I'm going to show you. You got to go get. So here we go. So the bill of sale, you know all about my challenges to the title and challenging the assignments. That's our bellwether. That's our lifeblood of winning these cases. So the bill of sale is the most referenced document, more than assignments, in complaints. You'll always see them say, hey, we own this debt, just look at the bill of sale. I'll give you two examples in a minute. But the bill of sale is chock full of great information for you. As I always tell you, the more they give you, the more they give you to hurt them. And the bill of sale, they have to show you because they don't have, and I'm going to show you why, the actual assignment with your name on it, assigning the debt from Citibank to Midland Credit Management. It doesn't exist, so they have to provide the bill of sale. But the bill of sale screws them big time. I don't know how else to put that legally. It's not good for them. So what we want to look for is the dagger to the heart. And at the end of the video, I'll show you why it is so and how to go get it. But one of the dirty secrets, it may be the number one dirty secrets as far as how to beat debt buyer debt collection cases, is to ask for what's called the forward flow agreement. That is ensconced, enclosed, incorporated right inside the bill of sale. I'll show you right now, and I'm just going to point. I don't have my usual deal, but my editor will do this. Here's a typical bill of sale. Shazam. And you can see, I'll read it. The Lending Club Corporation, a Delaware corporation. So you see a lot of Lending Club out there as far as fintech loans. And Galaxy International Purchasing executed an account purchase agreement. And the words forward flow, they actually call it a forward flow agreement. The terms of the agreement will govern the bill of sale. What does that mean to you? While they've shown you the bill of sale, and there's not much there, and you can have fun with that, but if something is governed by something else, that's relevant. If you're presenting a bill of sale and you're saying the whole bill of sale that I'm presenting you is governed by this agreement, you're entitled to it. And guess what? They do not want you having it. Let me show you another one. This is called a bill of sale dated as of the closing day. And they have these fancy names. Most of the times I go bill of sale and assignment. So they're trying to incorporate for the court that's reviewing this. See, we have everything. It says right there, bill of sale and assignment. So here's one bill of sale dated as of the closing day. Shazam. And that one says here, for value received and pursuant to the account purchase agreement. So a forward flow agreement is either called a forward flow agreement or an account purchase agreement. They always, then they'll put in parens, the agreement or agreement. It's one of those things where you do this for years and you're just moving along and you go, wait a minute, that's gold. So you have a right to that forward flow agreement because it says, and I'll just give you another one just to show and make my point. This one again is just called bill of sale. Shazam. Bill of sale for value received and pursuant to the terms and conditions of the purchase and sale agreement. That is powerful stuff. There is no court in the land that will say you can't have that when the bill of sale they're proposing is the gold mine of why they own the document. You're entitled to see why it's made pursuant to the terms and conditions. So it's totally relevant. You remember I just did a hearsay video? Let's put that up there. How to get documents beyond hearsay. It was just a little video on what hearsay means and the exceptions. The agreement always limits, and you know, a lot of times we always feel like, for example, arbitration. If you get forced into arbitration, the actual arbitration rules feel like they are against you. They are. The forward flow agreement is against the debt buyer. It's that good for you because they're buying debt pennies on the dollar. What does that mean? A debt is $1, they'll get it for 1 to 3 cents. So they'll get billions, literally billions. There are corporations like Encore and Portfolio Recovery that are publicly traded, and they are buying billions of dollars of debt for pennies on the dollar, and their shareholders are doing quite well in the last couple of years because with COVID and everything, there was a lot of debt, but it also put a lot of money into people's pockets initially to pay debt, so they went crazy. But these debts are paid for pennies on the dollar, but that entitles the buyer to go for the whole amount. However, that all thing is governed by these usual disclaimers in bill of sales. And it usually says, and I'll put it up, Shazam, this bill of sale and assignment is executed without recourse except as stated in the sale and purchase agreement. No other representation or warranty of title or enforceability expressed or implied. That's a debt owner, before he sells it to debt buyer, locking it down. When you see something without recourse, you cannot go after somebody legally. When you say, we're not giving you anything and we don't warrant the title, that means it's pure crap that you're selling them and you can't come after the debt seller. Well, what does that mean for you? That means that agreement is, there's lots of stuff in there advising the debt buyer that's now suing you, look, we don't have the proper paperwork, we can't make any warranty of title or enforceability, and it's without recourse, buddy. You take this smelly thing, you can't sue us. So the debt buyer buys the debt with that knowledge. So to then turn around and sue you and say, we own it, when the document that they've signed in agreement with says, we don't even own it, so you have it. You can see how that's illegal. It's just plain against the FDCPA, the Fair Debt Collection Practices Act. Let me just show you how, before I go forward, an average lawsuit, and again, we've talked about, look at my linchpin videos. There's one, there's two. Those are saying identify the linchpin of the complaint. That means what's their Achilles heel, what's their weakness, what's the thing they depend upon. And I'll just put up two right now. They both begin with the number 6, but they're from two different complaints. Shazam, Shazam. And they both say this debt or account, they don't even say debt, at issue was transferred, sold, and assigned from Citibank. See bill of sale. Next one says the same thing. It came from Barclays Bank, Delaware. See bill of sale. They open themselves up because now you look at the bill of sale and you'll see the forward flow agreement. Ask for it. So I'm going to tell you why that forward flow agreement gets you over the line, wins your case, gets your debt eliminated, or at least gets you a settlement that you're happy with. Remember again, they paid pennies on the dollar, and there's a reason why, because it's worth pennies on the dollar. Think about that. It's pennies on the dollar because it's worth just that, because it's a chance, it's a risk. They're paying pennies on the dollar and hope they can get $5,000 or $10,000. That's a nice profit margin. By the way, you're entitled to know how much they paid for your debt. It's listed right in the forward flow agreement. They all are. So here are some of the things that are in a forward flow agreement. I'm going to show you how to get that forward flow agreement, but here are some of the things in it. They all have, as I just said, a limited representation or warranties. They will say normally, we don't have everything, we don't have all the documents, we can't make any representations, they'll say we lack the documentation, meaning the original agreement and some account statements. How that is important. I did a video a couple of months ago. Let's go, it's called the PRA $24 million video. Shazam. And that is how the CFPB came down on portfolio recovery for suing people without the proper proof. Now, stay with me here. This is so cool. The reason they didn't have the proper proof is because that's the whole lifeblood of their business, is buying old debt that can't be proven without recourse, with no warranty of title or enforceability, for pennies on the dollar. So by virtue of their whole business model of buying crap debt and making it into gold, they are unable to provide what the CFPB says you must supply, and we're going to fine you $24 million because 5 years ago we asked you to do the same thing, you promised you'd do it, and you didn't. So they smacked them with a $24 million consent judgment that PRI signed, like they did the last one 5 years previous. And then it says you must provide the original agreements for the person that either seeks validation or gets sued and asks for proof. Well, if you think about it, that's their whole business model. They're buying pennies on the dollar. So they can't give anybody, because if they required that of their debt sellers, the Citibanks or the Barclays, then those guys would have to provide the paperwork, and they're not going to sell it for pennies on the dollar. So they can't, they won't, and it's without a doubt, the fact is, all debt that goes through a forward flow agreement in a bill of sale, that's what you're looking for, is as is, and it has it's sold without recourse, and that hasn't changed. For that to change, it would upset the whole business model that debt buyers rely upon, and their shareholders are not going to put up with that. So it also tells you that the seller is not responsible for the debt that they're buying to be legally enforceable, and we're not saying it's collectible. Those are the things that are inside the forward flow agreement. So if you're challenged, that you must go after that debt buyer and show the court that they don't have the proper title. You must cite the limited documentation that they have. Again, they don't have original contracts or applications. That's right in the forward flow agreement, and I'm leading somewhere with this. So without any real evidence, debt buyers can't honor what's called the best evidence rule. And the cool thing about the best evidence rule, it's exactly what it sounds like. You must provide the best evidence. That's a rule. And if they're unable to do that, and their usual schlock is to provide the bill of sale that references this gold mine, but rarely do you see the original contract or account statement showing you purchased anything, because they didn't get it either. They paid pennies on the dollar for it. Well, you can bring that up in your counteraffidavit, and I'll attach counteraffidavits that do just that to this video for you. By the way, this is all expressing and creating the number one thing that we do here. We show there are chain of title issues. So this is exactly the way it works. That appeal I did a couple of days ago before the snow at the Michigan Court of Appeals, I showed the court this chain of title has no link to the people saying they're selling it to, in this case, Velocity, and there's no chain of title from the real owners, what we determined to be Upstart Network, to Velocity to have sued my client. It was missing two links. That will be expressed in the forward flow agreement, because the forward flow agreement will confirm all this to say, we didn't sell them anything, and what we sold them was without recourse, and we don't think there's any enforceability of title here. That's why it's pennies on the dollar. So a debt buyer must prove they own the debt. So if you get a hold of that forward flow agreement, ain't no way it's going to do anything but good for you and hurt them. So that is your whole case. That forward flow agreement is your whole case. So how do we get those things and prod and poke them? Well, and you know what came to my mind suddenly, you will find these debts on your credit report. Midland Credit, Crown Asset, UHG, just all the usual suspects, PRA, Velocity, saying, hey, you owe the debt to us. The forward flow agreement inside the bill of sale says, we don't even own it, we can't prove it, but here, you take it. So I would argue quite successfully as I'm doing this, hey man, nothing on anybody's credit report from debt buyers can be true without that forward flow agreement. They will not want you to have it. So why is that thing on your credit report? So you want to include, immediately if you find something on your credit report from a debt buyer, send a dispute letter, credit dispute letter, and cite the fact that they don't own this debt and they haven't provided you any proof. Accompany that with validation letters to the debt buyer and ask for that. If they don't give it to you, that's good. If they give it to you, that's even better, but they're not. So I'm here to tell you, it's a really sour, sore part of this whole process for the debt buyer. They do not want to give that up because they know the truth. They know what's inside that, and it kills their bill of sale. There won't be any assignments of your specific debt. You can use that at court. It'll be in my counteraffidavits attached to this video. And if that agreement restricts legal action, and believe it, they do. They'll go, it's without recourse. I wouldn't sue on this. We really can't prove we even own it. It was 10 years ago, whatever it is. And it's going to be a general waiver that waives and makes the debt seller completely free of liability. So you better believe when you see something like, we have no representation, warranty, or title, enforceability, expressed or implied, and this is without recourse, we're selling you this direct, gotta believe the stuff they're selling is pure bad stuff that can't be enforced. So if you're getting sued and you see that language in your bill of sale, do a dance, because you're gonna win this case. Let's get to the point here. I'm gonna be doing 3 videos on this request to produce. I'm gonna show you how to get them to give up the stuff that they don't want to give up, and their only alternative would be to settle with you, because if they give it up, they're gonna lose the case too. So they're gonna fight you a bit, but you gotta make the request. So you gotta make a discovery request called a request for production of documents. And you're gonna be using discovery when you're granted at court. You can go another way that would really piss them off. If you subpoena the original creditor for the forward flow agreement, they really can't stop you from doing that. They could say, hey, we want to quash this subpoena, and the judge is going to go, why? And they will say, well, there's privacy issues here. We want our trade secrets protected. And the court's going to go, well, that's fine, but he or she is seeking that to prove you don't own the debt. Show me something that fits his need to a full chain. What you do is you bring the issue of chain of title right up front. And anytime they don't want to give something, that a judge is looking at that. Why? And you go, look, it's mentioned right in the bill of sale that they say in their lawsuit is everything. It proves they own the debt. It says they rely upon the terms and conditions of the purchase and sale agreement. Why wouldn't they want to give that up? They don't want to give it up, but their own bill of sale handcuffs them into your victory, all right? So if they start giving you trouble, subpoena it from the Citibank or from Barclays or from Cap One. You have to notify the other side, but just doing that, you're going to get a call that goes, hey, we really need to settle this, or they're going to fight you. But that tells you you're in the right place, okay? So I'm going to do a 3-part series telling you how to request discovery. Today's first part is how the most important thing is to go after this forward flow agreement. The next couple of videos will be, you got an affidavit attached to your lawsuit against you. Well, we have the important counteraffidavit, but I'm going to show you how to break down that affidavit. And normally, the reason why an affidavit is attached to a lawsuit is because they don't have the original contract, all right? And that's even with creditor cases. So if you can break down, again, refer to my hearsay video, but I'll show you how to break that down by asking for certain things. And also, when they attach assignments or say they've been assigned the debt, I'll show you a way to request to produce, force them to prove. And here's the thing. I'll tell you what I'm going to do. I'm going to tell you and show you how to go, hey, in that bill of sale, it references a forward flow agreement. Show me the assignment where my debt with my account number is passing from seller to buyer. It doesn't exist, but you have to ask. It becomes an issue, and that is either you in front of the court going, they provided me this and I'm asking for it, or it's them going, we just want to settle. It is really a sensitive place. I'm going to, I don't know if this is a metaphor or I'm not good with that stuff, but imagine a dentist and he has that metal pointed instrument, taps into a nerve, how that feels. That's how a debt buyer feels when he asks for the forward flow agreement. So I'm going to attach a request to produce discovery documents seeking that. My show notes, they're right in front of me. Again, I'm here, I got everything in front of me. And I'll give you a couple of copies of bill of sales, what they look like, and also a counteraffidavit that you start this litigation off by notifying the court, by notifying the other side that you've looked at the bill of sale and it references a purchase and sale agreement that isn't attached to the lawsuit. It has to be, if it's referenced and is relevant, which it clearly is because they depend on it, you can ask for it. It's totally relevant and it's a reasonable request. It's a hill to die on. So just as a side note, when I make discovery requests through interrogatories or requests to produce or request to admits, I ask for very few. The fewer you ask for, the more likely a court is going to pay attention and give you what you want. It shows almost respect for the court that you didn't go and just do boilerplate. Most law firms will boilerplate you to death. So if they want 3 things, they'll ask it 26 ways because they can bill per word or per line or per page. Don't kid yourself. That's really part and parcel why they do what they do. It's all about the billing. Or it's used to scare you. I've had other videos telling you how to handle discovery requests. This video is how to go after them. But you don't do it the way they do it. 3 to 5 requests. I'll add a document in Word for you to see exactly how to do it, how to send it. If you're in the middle of litigation, get this done. It scares the hell out of them. Remember the tooth. Ouch. So you'll get that case settled. All right, hopefully this is helpful. Hopefully next week I'll make it back home and have better weather. Thank you. Parker out.